Lordship, this is under very peculiar circumstances. This is affidavit of service. Or...
Before my learner starts, this is a matter relating to iris of the Central Act has been challenged. I do not know whether notice has been served upon the learned Attorney General or not. Second is relating to same issue. The matter is pending with the Supreme Court. Tomorrow is the date not for
Same issue. What is the issue?
iris of
Virus.
Lordship, in this matter, I have challenged the virus because here the wife has exceeded the age limit. However, the husband is within the age limit, although a donor gamete will be used for the wife, as has been prayed for. Lordship,
8
this
April 2025. There are several various high courts held in different ways regarding the virus matter.
Where from do you get that?
Initials orders are there. I have just
Tomorrow is the date.
tomorrow is the date.
List on 8th of April.
Yes, same thing. Here the virus of this assisted reproductive technology regulation Act 2021 is challenged. Various high court, our high court, though it is held intravirus, but granted relief. But so far as Madras High Court is concerned, Madras High Court said, it is absolutely intravirus and no relief was granted. So, various high court made different opinion regarding this issue. So, matter was
very well. Since you have challenged the virus,
only one submission in this regard. Lordship, I'm aware that the matter is pending before the Honorable Supreme Court, but now it has been pending since a very long time. And Lordship, today the petitioner number 2 before your Lordship is just aged about 52 years. She has lost a son who was 16 years old. I have both the husband and the wife, that is the petitioners before your Lordship, are service holders, one being a teacher and one being a professor.
No,
Lordship,
but then if the issue is pending,
Lordship, Lordship will kindly, Lordship, there are judgments to this effect. Lordship, very first matter where this issue was raised for this Honorable High Court, the pendency of this writ petition was only short. Lordship, I had indicated that even in where the subject matter is under consideration before the Honorable Supreme Court under Article 36 does not tie the hands of your lordships here, because Lordship, this is under peculiar circumstances. Today, I even stand a chance subject to me being physically fit. If Lordship may kindly, Lordship, this matter what I intend, Lordship, that each simpliciter, as Lordship knows, has made a criteria. Lordship, what I humbly beseech is, I have enclosed documents. I have enclosed all the other relevant documents. I have enclosed that the child has died at 16 years of age. I have enclosed that the petitioners, the property details I have enclosed. They are service holders. And
I told you in the morning, it is not only the financial status.
I bow down, Lordship.
Other factors are also to be considered.
Here, the gamete, I do not intend to use the mother's gamete. Only where the mother is coming into play is the mother wants to bear the child in the womb. After everything, the process, Lordship, is aware that an egg, that is a ovum of a woman, is used and the sperm of a male person is used. And Lordship, the fertilization is outside the body. That is how IVF is done. The fertilization is outside the body. Here we say that the ovum or the egg of the mother will not be used, so that the quality of the life which will be coming to this world is not, even if that be the consideration, that can be avoided, Lordship. And there is a provision in this statute, I will show, Lordship, that there is a scope where the embryo can be tested for the quality. The testing of the embryo, the quality of the embryo can be tested prior to implantation. So, Lordship, what I humbly beseech is, here the role of the mother or the petitioner number 2 will only be to the extent that she will be carrying that embryo which will be implanted in her womb. That is all is the role which will be played by the mother. Lordship, if an independent medical board may be constituted to see that whether the mother can be, Lordship, that she is otherwise healthy, whether she can carry a pregnancy to a full term, Lordship, if that may be permitted in the meantime, Lordship, we can come back to your Lordship, but she is already 52. Today, if I even stand a chance, Lordship knows that this matter takes how long before the Honorable Supreme Court. And this matter has been pending since very long, if not for two years.
Yes, I see. 2022, it's
yes,
pending.
Lordship. And in this writ petition, Lordship, I can show orders where several matters have been directed for consideration before the respective high courts, because even the Honorable Supreme Court is aware that age is a factor, the biggest consideration here. So, Lordship, I humbly beseech that age simplicity. I will address your Lordship on the points of law, or what the law was before and what the law is after the statute has been enacted. But I can only do that subject to your Lordship is satisfied that this petitioner number 2 may carry that pregnancy. If your Lordship may, subject to what my submissions are, Lordship, your Lordship will kindly see that she has lost the child who was Bornik Pal, Lordship. The child was born on 4/6/2006, annexure page 23. He has died thereafter on Lordship. His date of death is, Lordship, it is at where is the date?
16 June.
1665. Sorry. She has died. I have included all the property details they have. I have included that they are service holders earning handsome salaries, both the parents. The mother has been certified to be performing well in her school. So she is an active lady, Lordship. Only because age simplicity has become a criteria and she is above 2 years now, Lordship, that is the only hurdle. The father is within the age group. Lordship, this has got other repercussions. Lordship will also appreciate that the father will be.
What is to be done?
So, my lord, so far as Act is concerned, my lord, Act is not clear. My lord, this aspect of this issue, my lord, has been dealt with by the Madras High Court. My lord, can you remember the judgment of Madras High Court? I know, my lord, your lordship judgment.
Who was overaged over here?
Over
Lady.
Lady.
Madras High Court, the lady?
Yes, yes.
Yes.
My lord, this is WP number 35158 of 2024.
WP
35158 2024.
351
35158 of 2024.
58 of 24 Madras.
Yes. Now, if your lordship will not kindly turn, my lord, inner page 7, paragraph 7. It says, not a reading of section 2U of the ART Act would indicate that it prescribes the only lower age limit, no upper age limit has been prescribed. In the considered view of this court, the legislature in its wisdom purposefully avoided the incorporation of the upper age limit in the definition of the word woman. Section 27(2)(b) of the Act prescribes the ART Act shall obtain the assueties from the female. Oocytes from the female between the age of 23 years and 35 years. However, the Act prescribes the upper age limit of 50 years for a woman who seeks the ART services under the 21G of the Act. In other words, a woman is entitled to donate oocytes only up to the age of 35 years. However, she is entitled to be the recipient's gametes up to the age of 50 years. Since two different upper age limits are prescribed for a woman who is a donor and the woman who is the recipient, the legislature, in order to avoid confusions, would have consciously omitted the upper age limit in the definition of the word woman. Alternatively, this court would like to point out that nowhere in the Act the woman is given a right to seek the services of the ART except under section 21G. Even under the said section, the woman conferred with the said right indirectly by imposing a statutory duty on ART clinic and bank. When the specific section 21G ART gives the restrictive meaning of the word woman by prescribing the both upper age and lower age limit, the same prevail over the definitions in the general definitions section.
I will come back on being.
WP. Well, I will be relying on, my lord, certain frequent question answers or ART regulation 2021. This is, my lord, issued by, my lord, Ministry of Health. I am handing a copy to
Thank
you.
you.
I will be relying on that.
Possibly this was considered in the judgment which was delivered by me in the morning that you showed. Possibly this was considered.
I will go through that also.
Please
Lordship,
come.
there is also, I will also indicate that I have mentioned in my petition also that what the law was before the enactment. So that
Yes, sir, the
that will
object
also, yes.
Yes,
I
but object clause, 5D is also there. Object clause is also.
the petitioners as commissioning couple intend to avail the benefit under the
ARTN.
ARTS Act. Stop next. The petitioner number 2, the wife, has crossed the prescribed age limit of 50 years by 2 years. But the husband, petitioner number 1, is within the prescribed age limit. Stop. Whether the petitioners may be permitted to avail the benefit of ARTS is to be decided. Stop. Learned advocate representing the Union of India submits that the virus of the act is under challenge before the Honorable Supreme Court. And the next date fixed for hearing is tomorrow, 8th April 2025. Stop. Reliance has been placed on a judgment delivered by an Honorable Single Bench of the High Court of Madras on 7th February 2025 in WP number 35158 of 2024. Stop paragraph. To allow the parties to come ready with hearing, relist the matter on when do you want it?
Lordship, Friday 11th, if your lordship is, it's gone.
11th.
I'm deeply obliged.
Service is taken on record.